SJC-12197, Commonwealth v. Frederick Pinney.
Mr. Thompson and the Thompson family, good morning.
Good morning, Chief Justice Gantz, Justice Lowy, Justice Graziano, Justice Cipher, Justice Kafker. I'm John Thompson. I represent Frederick Pinney in this appeal of a denial of relief under 211-3 by a single justice of this court. This case involves a claim that the evidence is legally insufficient to proceed any further. Claire Moore smoked marijuana 30 minutes or less before she died. And that's a significant fact because it destroys one of the premises of the Commonwealth's case. The Commonwealth's case was that Frederick Pinney must have killed Ms. Moore because the two of them were alone together in a house when she died.
Can I ask you a factual question? I assume they all are, but I think in your brief I read that there was an absence of evidence. I mean, obviously, the incriminating circumstance of her being found near naked in your client's locked bedroom, right, is an issue. But I think you wrote that there was no evidence of contact between your client and her body, correct?
I may have said that.
And the reason why I want you to explain for me, if you would please, is the DNA, the blood spot on her breast, which was your client's DNA, right?
Yes, there was a spot of his blood was found at the autopsy on her rib cage below her right breast.
All right, and does that indicate anything as far as your client's access to her and how she died? Because it's a strange thing, because your client obviously stabbed himself.
He had cut himself many times.
Right,
He had
and
attempted suicide.
she died by ligature strangulation.
That's right.
Okay.
Well,
Can you explain that, please?
It's not evidence of contact between him and her because this is evidence that was discovered during the autopsy. Before that happened, the police officers arrived, and there was testimony by an Officer Lozado, the photographer, who said, when we arrived, I took photographs, including photographs of her body, to document the circumstances when we arrived. There was no photograph of blood of his blood, or that blood spot on her rib cage at that time. There was a photograph of her being turned over onto her right side while she was in the room. And of course, there may have been blood on the floor. So while his blood was on her body at the time of the autopsy, that is not evidence that his blood came into contact with her because of any physical contact with them.
Was that blood stain visible post in the autopsy?
It was photographed.
Right, but it
was visible.
It was visible.
Yes, and there was expert testimony about this. There was
Sorry, go ahead.
The witness, the Commonwealth had a blood spatter or blood pattern expert testify about this blood transfer. And she was not able to say when the transfer occurred or how it occurred. So while there was blood on her rib cage that was his blood, there's no evidence of how it came to be there or when it came to be there.
And if perhaps I read it more carefully, but if we look at a photograph of as she lay on the floor, we'll see an absence of blood on her rib cage.
I don't know that there's a photograph that shows her rib cage before when she was located. But if you look,
is that why they didn't take one, or was she dressed, or what was the?
She was completely undressed except for a sock on her left foot, I think.
But did they take a full frontal photograph?
Yes, they did.
But they didn't show her rib cage?
It does not. It does not clearly show. There's the autopsy photo is Exhibit 95. And the testimony from Officer Estrada is the February 1st transcript.
So you're not arguing, I just let's be careful, you're not arguing or contending that there's a photograph that showed an absence of blood. You're just saying there's no photograph to document that there was blood on her.
Yes, and Officer Estrada testified directly that he came there and his function was to document the condition of the body and the scene at the time they arrived. So when they found blood, when they found other significant items of evidence, they documented that in some way. They'd put a sticker or a marker near it and then photograph it. So the absence of fair inference is that the absence of a photograph of her rib cage with blood on it is that the police did not see that at that time.
Certainly the jury could draw that inference, but that seems like a weight issue. You're not saying that in trying to calibrate whether or not there's enough evidence to meet the Commonwealth's burden of production that we can't consider that there's the defendant's blood under the victim's breast and her body that's in his bedroom with the door locked. Are you?
I'm not saying that it can't be considered,
Okay.
Justice Lowy. I'm saying that it doesn't support a reasonable inference that it was from contact with him. It's not the kind of inference that a jury could draw from their common sense. There was an expert who came in to testify about those things, that is, blood transfer and how they occur and when they occur, and that expert was not able to say when that transfer occurred or how it occurred. So when it comes to drawing a reasonable inference from the fact that there was blood, his blood on her rib cage, and that was the only evidence of contact between him and her.
Well, she's also in his bedroom, right?
Yes, but that doesn't establish that there was contact between him and her. She was in his bedroom, and that was it. The focus, though, has to be on what happened when she died. Mm-hmm. And a fundamental flaw in this case is that the time of death issue does not support an inference that she died at a time when the two of them were the only two people in the house.
Well, I don't want to go through marshaling everything, I'm sure the prosecutor will, as it relates to Commonwealth versus Lattimore, but the rigor mortis evidence, or whether or not he was alone with her at a particular time, those were all important points, and they're valid points to argue to a jury. But what we're doing is we're looking at the record,
yes,
and seeing whether there's enough evidence in the light most favorable to the Commonwealth. So the fact that the rigor mortis evidence isn't dispositive, or that the defendant might not have been alone with the victim at the time of death, doesn't impact when we take a look at the box of evidence and see if it's enough to survive a required finding.
I don't see how it can't actually be critical, Justice Lowy. That is, I think it's important to look closely at the rigor mortis evidence. Rigor mortis is a medical phenomenon that is not something that lay jurors can evaluate without expert assistance. The time of death, rigor mortis is one way or one factor to look at in trying to establish a time of death or a post-mortem interval, that is, the time between when the person died and when the body was found. But that's not something that's open to people to judge on common sense. People don't, that's why we have experts for it, and the Commonwealth presented expert evidence on that. That is, the medical examiner here on this report reported a judgment about that. This is Exhibit 112. It's in the appendix at page 248. This is the death certificate. And in section 37C, approximate time of death, it's marked unknown. That was presented as evidence by the Commonwealth, and it is, under the statute, it's prima facie evidence of the facts that are contained in it. This is an expert statement that the time of death was unknown. Now, the Commonwealth tried to get the jury, or ask the jury, to draw an inference from observations that a paramedic made And from a few statements that the medical examiner made about the general time frame in which rigor mortis may occur as a general principle, but that wasn't enough information to allow the jury to draw a reasonable inference about time of death. The, excuse me, I laid out in my brief the fact that medical examiners say, as a general rule, that rigor mortis by itself is not enough. And the case law that's cited particularly in our reply brief establishes that as a fact, as a practice among medical examiners. There are a number of variables that are involved that also affect the time of death and the rapidity or slowness with which rigor mortis develops. Things that weren't taken into account, that are present, factors that are present in this case. So the time of death evidence was not sufficient. It wasn't strong enough to allow the jury to draw an inference about when she died. And their own expert said, it's unknown. The time of death is unknown. So their case to rule out Mr. Podgorski, the boyfriend, was an alibi for him. That is, he testified extensively trying to say that he wasn't there, that he was elsewhere at various periods of time. But there was a period of time. He went to the house at 11 o'clock in the morning. He was there for 99 minutes at least before he contacted the police. He did not account for the time that he spent there. But this is a period during which she might have died. The jury could have found that she died after 11 o'clock in the morning. The boyfriend was there. And this ties in to the marijuana evidence. She smoked marijuana probably just a couple of minutes before she died.
Well, why is that so important? I mean, she could have had her own marijuana, right? Or her boyfriend could have given her a small stash. Why is that so critical? I find it odd a little bit, but go ahead, explain to me.
It's critical, Justice Kafka, for this reason. It is the only reasonable inference that can be drawn from the fact that she smoked marijuana a few minutes before she died is that somebody else was with her.
Why? Well, people smoke marijuana by themselves all the time.
They do, but there's no evidence that she had her own marijuana.
Well, but we know that she and her boyfriend smoke marijuana all the time.
We do, but
and
he
why
testified.
Why do we rule out that she has any marijuana of her own?
Because there wasn't any there after they discovered her body. There were 2 search warrants executed at that house.
So that's the reason.
After they found her body. There wasn't any marijuana found there. There was some cocaine found there. There wasn't any marijuana. There wasn't any rolling papers. There wasn't a pipe. There wasn't detritus for marijuana. And he testified that he was there after 11 o'clock, and he smoked marijuana in that house, and evidently he cleaned it all up. So
I thought he smoked in the car or outside. Or he smoked in the car or in the house. I can't remember.
he smoked in the house. He said that at 11:23, he sat down. He had already searched the house. He couldn't find her. He had looked in every room except Mr. Pinney's room. He went back downstairs. He plugged in his cell phone, and he rolled, or as he said, he rolled a blunt. The way he smoked marijuana was to crack open a cigar, empty out the contents, and put the marijuana in, and then smoke the... So that's an activity that would generate detritus. That is, at least there would be tobacco. There wasn't any of that there. None of that was discovered. So the only reasonable inference is that he was there, he smoked marijuana, he cleaned up, and then he went outside and he called the police from outside. But he smoked the marijuana inside. So the fact that there was no marijuana in the house means that she was not alone when she smoked the marijuana. Now, there's no evidence linking Pinney to marijuana at any time, at any place. So he could not have been the one. He had taken 20-gram lorazepam pills, and as Podgorski testified, the way they affected Ms. Moore was they put her to sleep. And that's why he made her quit taking them and gave her marijuana instead. His testimony shows that he controlled the marijuana. He was the drug dealer. He provided marijuana and cocaine and lorazepam to Pinney and Ms. Moore and for himself. And so the evidence that we have here points to him. It doesn't matter whether it was him or someone else. For the sufficiency of the evidence, the point is, time of death is not established. She could have, certainly the time frame that the Commonwealth is arguing, from 12:50 in the morning to 4:50 in the morning, that is not established. She could have died between 11 and 12:50 midday. The marijuana means that there was somebody else with her, not Pinney. It could have been Podgorski. It probably was Podgorski, but it wasn't. Both of the pillars that the Commonwealth's case is built on. She was alone. The two of them were alone together at the time she died. Both failed here. You can't say when she died nobody else was with her. Podgorski was there part of the time. And the marijuana shows that a third party was there, not Pinney. It could have been Podgorski. And so for that reason, we have a Berry kind of situation. Berry versus Commonwealth, Commonwealth versus Salim, where there are two or more people who could have committed the crime, and you can't say which one of them did. And here, there's no motive evidence for Mr. Pinney. There's motive evidence for Podgorski. There's no motive evidence for him. There's no evidence of a ligature that's connected to him. There's a ligature in his room that was tested for DNA. His DNA was not on it, but Podgorski could not be ruled out. And there's no marijuana linked to him.
All right. Thank you, Mr. Thompson. I think your time is well up. Thank you. Ms. Lynch.
I'm not sure if it's good morning or afternoon, but may it
on the
please the
cusp.
court. Bethany Lynch, Assistant District Attorney for the Commonwealth. In this case comes before the court on an appeal from a mistrial was declared, and the defendant has filed a motion to dismiss based on double jeopardy grounds. And in this case, so long as the evidence, when viewed in the light most favorable to the Commonwealth, was sufficient, double jeopardy does not bar the retrial of this defendant. Now, this defendant was tried for first-degree murder under the theories of deliberate premeditation and extreme atrocity. I don't think at this point that there's any contest or any disagreement that the evidence was sufficient that someone committed either a deliberate premeditation, deliberately premeditated, or a murder with extreme atrocity and cruelty. The issue comes down to who was the perpetrator, and that was the issue at trial, and I would suggest that's the issue here. Time of death is an important key to this case, and I would suggest that there was sufficient evidence of the time of death. We did not have an eyewitness to testify. We did not have a video. We didn't have anything that specific, but what we had was the paramedic who arrived in response to Mr. Podgorski's 911 call, found the victim. Her upper extremities were stiff, her jaw, all of her large joints, including, her jaw, her upper extremities, her hips, her knees, her ankles. All of those were stiff, and her skin was cool to the touch.
But a jury's not going to understand that, are they?
They are not, but in combination with the medical examiner's expert testimony defining what rigor mortis is, those two pieces of evidence taken together draw the inference. The medical examiner testified that she described rigor mortis.
Draw the inference that it couldn't have taken place during the 98 minutes that the boyfriend was in the house?
It could not, according to the definition of rigor mortis provided by the medical examiner, and she testified that the small muscles of the body stiffen first, including the jaws and the hands, and that happens within 2 to 6 hours of the body having been deceased. Then from there on, it moves down the body into the bigger joints. There's a progression that occurs, and it ends with the larger muscles, particularly in the arms, legs, and torso. That's what we had here, according to the eyewitness testimony of the paramedic, was that her joints in her lower torso were stiff by the time he examined her. And that, according to the medical examiner's expert testimony, takes between 8 and 12 hours.
Do you, say we don't agree with you on that, isn't there enough evidence otherwise? The fact that his blood is under her breast?
Yes,
that-
I would
that
suggest-
she's found naked in his bedroom, that the other person is gone a huge chunk of the time, if not all
Yes.
the time. I mean, do we really need to, do you need to win this rigor mortis point? 'Cause it seems.
I don't know that I need to, but the focus of the trial was on the defendant's attempts to blame this third party and the fact that the third party was equally available to have committed the crime. And so the Commonwealth presented a great deal of evidence accounting for his time during the presumed window of the cause of death.
I mean, if we were
I'm sorry,
trying to
time of death.
preserve the conviction, I think this might be a little trickier, right? But
Yes, but, you know, there was evidence not only that the boyfriend didn't do it, but there was significant evidence, all circumstantial, of course, except for the blood underneath the victim's right breast. And I would point out that the evidence at the trial showed that the blood was underneath her right breast. There was no particular picture of her breast lifted at the scene of the crime. And also, this issue came up about the possibility of transfer, and there were pictures that showed that on the floor next to her, prior to her being turned by the paramedic, those pictures aren't evidence, and they do not show any blood on the floor. So the theory that the blood more likely transferred from the floor than from the defendant himself, the defendant had cut his wrists, he had blood on his arms when he was found the next morning. So the expert testimony described it as a transfer stain under her breast, and the transfer stain was of his blood. So I would suggest that the more reasonable inference was that in moving her in some way, he transferred the blood from his cuts that he had inflicted upon himself underneath her breast when moving her. Trying to get away from the rigor mortis issue. The defendant was alone in the house with the victim at the time that we believe that the death occurred. The doors were locked. They were still locked the next morning when Christopher Podgorski arrived. Only the defendant, Christopher Podgorski, the boyfriend, and the victim had keys to the house. The victim was killed by ligature strangulation by another. She was found unclothed on the floor of the defendant's bedroom, the defendant's locked bedroom. When Mr. Podgorski attempted to locate his girlfriend the next morning, he banged and banged on the door. The defendant did not answer. Finally, he did answer. He came to the door. He opened it. He kind of shimmied out the door and closed it quickly behind him. Then when Mr. Podgorski insisted that he see inside the room to see if his girlfriend was in there, Mr. Pinney went downstairs, got the key to his bedroom, and came up the stairs also with the knife in his hand. At that point, he did unlock the door, and Mr. Podgorski saw the victim's legs prone on the floor. He did not enter the room, and he immediately left and called 911. This is all testimony of Christopher Podgorski, which, in considering sufficiency, is viewed with credibility determinations in the favor of the Commonwealth. The victim was cold to the touch. She did have stiff joints at the time the paramedic arrived. The defendant also lied to the police when they arrived in response to the 911 call and said that he was alone in the house, despite the fact that he would have had to have either stepped over her body or shimmied around her body to get out of the room. It was a small room. The pictures depict this. And the size of the bed and the other furniture left a sort of a small area for the victim to be in. And she was splayed out. She covered up most of that space. He also told Christopher Podgorski that the victim had left in the night. She got angry and she left. At about 4:30 in the morning, Mr. Pinney texted Mr. Podgorski to say that that the victim was all effed up and that he was going to bed, and so again, implying Mr. Podgorski wasn't there. The defendant also attempted to commit suicide. We don't know the timing of this, but it's another factor because consciousness of guilt is something that can be considered for sufficiency purposes, and he did attempt to commit suicide in multiple ways that evening. On top of that, there was evidence that Mr. Podgorski wasn't at the scene. And I think it's set out in my brief, but he basically was in Holyoke the night before the St. Patrick's Day parade. He was in bars, he visited friends, he received phone calls at his mother's house. All the cell phone tower information corroborates this. So Mr. Podgorski, the only other real suspect in this case, was not anywhere near Springfield at the time that the Commonwealth would suggest that this murder took place. In light of all of that evidence, the Commonwealth would suggest that the evidence was more than sufficient to reach the jury, and that the motions for required finding, the 25B2, the motion to dismiss, and the single justice, all of those rulings finding that the evidence was sufficient, should also be the same conclusion that this court reaches. If the court has no further questions, thank you.